So going back to what does this rule pertain to? Pre-1978 houses, we talked about what that means when the building permit was pulled. Pre-1978 apartments or other multi-family housing units. It also applies to pre-1978 child-occupied facilities, schools and daycare. So if you're selling a commercial building and you have a component of that, which is a daycare or a school, and it's a pre-1978 building, then that particular area of the building will be affected. Pre-1978 housing for the elderly and or disabled in some situations, and we're going to talk about that in just a minute, what those situations are. This is how they define a child-occupied facility. You might want to hold on to this piece of paper because it's kind of a complicated issue. Visited regularly by the same child under 6 years of age at least 2 different times a week. Each visit must be at least 3 hours long, and the combined weekly visits have to be at least 6 hours. Combined annual visits at least 60 hours. Everybody get that? Yeah, that's how they define it. So, you know, if you question whether or not something is a child care facility in a building, you get out your calculator and you start asking some questions, and that's how you figure it out. And that is their definition. Yeah. Now, as far as common areas in child care facilities, it only pertains to common areas that the kids actually use. So if they use the restrooms, they use the cafeterias or an eating area, only those areas that are frequently visited by the 6-year-olds or under. And any exterior parts of the building that are adjacent to the child care facility or the common areas used by the children under 6 years of age. Okay. So again, if you have a building that has a component of this, the entire exterior will not be affected. The entire building will not be affected, but there are rules for determining what areas will be affected. This is property that is not affected by this rule. Housing built in 1978 or later, residential housing. Housing for elderly or disabled buildings built prior to 1978, and this is the part we're coming back to, unless children under 6 reside or are expected to reside there. So if you have an elderly home or a residential home for the disabled that are not going to have kids under 6 there, expected or do reside there at the time, then it's not going to be a property that falls under this rule. But if the kids are coming there regularly, then it is going to fall under this rule. 0-bedroom dwellings, such as studio apartments, barracks, dormitories, they are not included in this rule. And any housing declared lead-free in writing by a certified inspector or risk assessor. And we're going to talk about what that means, certified inspector, in a moment. The pre-renovation requirements that are in effect now require and there's a different pamphlet that came out, but these rules have been around for a little while, require people, renovators, contractors doing renovations in these homes to provide a pamphlet to the owner of the home that talks about lead-based paint. The name of the pamphlet that must be distributed now is called Renovate Right, Important Lead Hazards, Information for Families, Child Care Providers, and Schools. And this is the renovation information that will be provided at the time the contractor, prior to the contractor beginning the renovations. And we'll talk a little bit about notice requirements in a minute. This program covers the training, the certification of renovators and renovation firms. Work practice requirements before, after, and during renovations. In other words, what they have to do before they begin, what they have to do, and that deals with both notice requirements and prep work, and then how they have to conduct the renovations, and then how they have to conduct the cleanup after the renovations are done. This all falls within the program. And then there's a record-keeping component as well. Renovation is broadly defined. It includes most painting, plumbing, and electrical work, remodeling, maintenance activities, carpentry, anything that disturbs painted surfaces. It does not include, as I pointed out a few minutes ago, anything where you're just going in and painting over something and there's no disturbance of the paint. In dwelling units, prior to a certifier beginning any work, they have to give notice to the adult occupants. You are not the monitor for this certification firm. So if you make recommendations to your client these are some firms that are certified to do repairs on this property, and they go out and they hire that firm, then you are off the hook. You are no longer responsible for problems that that firm causes or things that they do or do not do right. However, I think it's important for you guys to have some background or some information about what they're supposed to be doing. So if you determine that there's a problem, you know, because of this class or because of reading material, that they're not giving out the notices, that they're not doing some of the things they're required to do, that you can either point that out to your client so that they can look into it further, or you can bring it to the attention of the certified contractor. Again, it's not your responsibility to oversee the process once you hire the right firm, but I think it's important for you to know what they're required to do. So you can make sure, if you see something that doesn't look right, you can bring it to the attention of your client. They have to give notice to an adult occupant in the dwelling unit about what's going to be happening. And the notice has to include the date and time of renovations, you know, when it's going to begin, when it's going to end, the nature of the renovations, where the renovations are going to take place. They have to get a written acknowledgement from the occupant they received the notice, or they were unsuccessful, or explain why they were unsuccessful in delivering it. For whatever reason, they couldn't get it to the occupant. It has to be given no more than 60 days before beginning renovations. That's important from a property management standpoint, because you can't give it to them at the time they enter into a lease agreement, for example, and it's going to cover them for the whole year in the event you want to do renovations in the property. The rule requires no more than 60 days before beginning renovations. And if it's mailed, and it can be mailed, you must have proof. The certified contractor must have proof mailing was done at least 7 days prior to the start of the renovations. Again, the notice has to give the nature, the location, the start and end dates, and how to receive the pamphlet at no charge. So the firm can either give them a pamphlet at that time, or they can tell them how they can receive a copy of the pamphlet from the firm, free and at no charge. So the firm can't direct them to the EPA website to download the pamphlet. They have to actually get the pamphlet from the firm. Alternatively, they can post informational signs giving the same information. They have to be posted somewhere they're likely to be seen, so they can't be off in the corner somewhere. And they either have to have a pamphlet with the informational sign, or again, information on how they can receive a free pamphlet from the firm. If initially in multiple dwelling units, for example, if they decided to give notice to each one of the dwelling units, that's the option they took, opposed to posting informational signs. And then they decide to change the nature of the renovations. They decide it's going to take longer, they're going to do some more extensive renovations, whatever the case may be. They have to go back and notify each of the dwelling units independently, if that's how they notified them to begin with. If they did it by way of informational signs, posting informational signs, then they don't have to do that. But if initially they notified each one individually, they have to do that same thing again, and they have to do it before they start any additional renovations or make any changes to the renovation plan. In child-occupied facilities, again, there's a 60-day requirement that they have to notice them within 60 days of, no more than 60 days prior to beginning the renovations. Again, providing the owner with the pamphlet, receiving the written acknowledgement, and again, if it's mailed, they must have proof that they've done so at least 7 days prior to the renovation. If the owner is not, the occupant is not the owner, you have to provide the same information to the adult representative and receive the written acknowledgement from the adult representative. And again, the same mailing requirements apply. No more than 60 days before beginning renovations, they have to provide every parent or guardian of the children that attend that facility with information, with the notice, the nature, the location, the start and end dates, again, mailing or hand delivering to each parent. Alternatively, they can do the posting again, giving that same information with the pamphlet or information on how to obtain the pamphlet. And the firm has to take steps to, must be able to certify all the steps that they took to notify all the parents in the facility. As of April 22nd, this is when all the certification requirements come into play, and firms must be certified. They have to have all employees trained in use of the lead-safe work practices, and they have to implement lead-safe work practices that minimize occupants' exposure to lead.